Seriously?
Yeah, first meeting of the year.
I'm an outside.
All right, it looks like we're on the record then, so if I may, I'll just break on in there. We may have Judge Rambo join us here shortly, and when he does, we'll just greet him and then just continue rolling on through the agenda, okay? First of all, let me call roll. Britt Collins, he's absent. Ken Gibson.
Here.
Judge Rambo, he'll be joining us later. Miss Morgan.
Here.
Mr. Mansfield.
Here.
Mr. Houston.
Here.
All right. Looks like we have a quorum, so we'll move on to the notice of meeting. Notice of March 22nd, 2019 meeting of the Court Reporters Board was posted to the Court Reporters Board website March 14th, 2019. As with all teleconferences, we always have to do a statement of necessity and a vote on that. And then every actionable item, we'll have to do a roll call vote as well. So just keep that in mind as we move to the actionable items. The statement of necessity is such. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at the meeting require timely action by that body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is a regular scheduled meeting of the Tennessee Board of Court Reporting, and the purpose of today's meeting with some members attending by teleconference is to discuss the agenda as noticed on the website earlier. If that's an acceptable statement of necessity, we would entertain a motion to accept that as our statement to be filed with the Secretary of State. Do we have such a motion?
I make a motion.
Thank you, Mr. Mansfield. We have a motion to accept the statement of necessity. Do we have a second?
Seconded, Earl Houston.
We have a second from Mr. Houston. Now for roll call vote. Mr. Gibson?
Yes.
Ms. Morgan? Yes. Mr. Mansfield?
Yes.
Mr. Houston?
Yes.
All right, thank you very much. We'll move to the next order of business, which would be the agenda. Everyone's had their had an opportunity to look at the documents in advance. Is the agenda suit everyone's needs? Or is there any amendments or edits that you'd like to make? This would be the time to do that. Any comments? Or if not, then we'll entertain a motion to accept the agenda. Ms. Morgan made a motion to accept the agenda. Do we have a second to accept the agenda?
Second, please.
We have a second from Mr. Mansfield to accept the agenda for a roll call vote. Mr. Gibson?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Houston?
Yes.
Thank you very much. The agenda is accepted. Judge Rambo, is that you on the other line? Okay, I thought we had a call in. All right. We'll just,
You do?
oh, great. Great. Thank you, sir. Welcome. We just accepted the agenda. We have quorum also with your presence as well. So we're at the September minutes now. The September minutes, I trust everyone had an opportunity to look at that. Does anyone have any comments or edits or in regards to that?
This is Ken Gibson. Would you add me to the list of people present at that meeting, please?
Yes, sir. Indeed. We apologize that you were missed there, but we'll add you there.
No problem.
Any other edits? All right. With that amendment, do we have a motion to accept the September minutes? Morgan made a motion to accept the September minutes. Do we have a second in that regard?
Second.
Mr. Mansfield seconds the approval of those minutes with that amendment. Now for the roll call vote. Mr. Gibson?
Yes.
Judge Rambo?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Houston?
Yes.
Thank you very much. They've been approved and accepted. We'll move on to the director's report. The budget report is just for informational purposes only, so there won't be any reason to vote, but we'll go through that. At the first of the year, we always try to go over the fiscal year prior as well, to kind of do an overview of the total budget health, and then drill down for the trend analysis. So that's what we have on the first page. It's basically the fiscal years prior. All right. Let me take a look at that. I'm just going to point out the key points. And then as we go through it, if you have any questions, just let me know, okay? And then we'll drill down further. But right now, I just want to point out the highlights that I saw. If you look at the revenues, so let's start there, or expenses rather. Very top portion, you have in the middle a grand total, which is your expenditures, and then below that the revenues. If you look at expenditures right there in computer-related items, you'll notice on fiscal year 17-18 we have that $59,000 there. That is the far right column. That's a big number. That's the core. That's where we came on board, the website, and then enhancements, subsequent enhancements. So obviously that's going to make an impact on our net surplus or deficit for the end of the year, and you'll see that as we go down further. So if you go down to total expenditures a little further, all the way down, you get past administrative cost backs and total cost backs, all regular line items, total expenditures. If you compare all the years, fiscal years prior, you got 22,000, 20,000, and 86,000. Big number. That's the computer-related website and the one-time sort of fee. So just keep that in mind. That's what that is. Which brings us down to a reserve balance. It was a moderate increase on our reserve balance, primarily because the expenditures ate up that surplus. But we're averaging several thousand each year in surplus, so we're in a good place. If you go to the second page, those are your administrative cost backs. Basically, every program is allotted administrative cost backs. What that is our share of of all of regulatory board's expenses. Court reporters is a small board. We shouldn't be. You don't want to equal part with maybe a board like the size of Cosmo and Barber, who has 60,000 licensees, and so we that's taken into account. They take the number of licensees, they take the complaints. And then from that, they come up with an amount. And if you look at that green, where it starts to become green, administrative cost backs, they come up with a percentage of the total program's expenses. And so our share of that last year was just under $10,000. So out of all the programs, Court Reporters shares, basically, if you look next to that, the column next to that, we share right at 0.1% of all the programs. Cosmo and Barber alone, they share roughly like 16-17%, to give you an idea. Total of programs, and that's basically building expenses, stuff that we can't itemize directly to a program, but we have rent, and you've got salaries, things like that, vendors where they do the IT support across the board. That's general. Well, we have to break that up and apportion that. So that's what administrative cost backs are. That's what you're seeing there. So under $10,000, pretty moderate. Well, let's go to the third page, which is the trend analysis. That's more the month by month kind of drill down look of what we're actually experiencing budget wise. And so a few things I want to note there. Let's look at let's first talk about that red at the bottom. All right, that we typically run in a deficit until we hit our biannual renewal cycle. When that happens, that's where we make up the difference. So if you look at July, we have a surplus there. That's basically some holdover from the renewal cycle in June. June is a big spike. And so you'll see, and then there's a little bit of that flowing into July. So it's pretty common that we run in the red after that. And of course, it balances out at the end of the year. So that's what we're looking at there. Let's see. Let's talk about the spike in revenue for. There was a spike received in August, I believe. Yes. Yeah, there's a reallocation rather in revenue. If you look at the very top of licensing revenue in August, you see that reallocation there, that negative 13,000, which left us in a deficit for that month of 15,000. That was significant. What that is the credit card statements that were paid in July. They had to recorrect those. So it was showing up in August, but it was actually paid and accounted for in July. So they're making a reallocation there to account for that, those credit card statements on those renewals. So that's what you're seeing there. So nothing out of ordinary there. Let's look at technology. If you go down further, under Edison expenses, technology and other, you'll see a spike in expenses there under October. You see that $2,000 and that $1,000 right there. That was due to an increase in total administrative cost back for period 4 expenses, and all the programs saw that because there was some enhancements to Core through Microsoft that we ordered some code drops through the vendor, and then that was spread across the programs. So that's what you're seeing there, both in technology and other. Those are Microsoft vendor enhancements. That's all I have for the budget. The last page basically is just your line items explaining what those accounts are in essence. But the heart of what you're looking at would be page 3, which is your trend analysis, which we just went over. Is there any questions on that? Okay. If there's no questions, then we'll move on to the next piece, which is Robert's Rules. The first of the year, with our first meeting for all of our boards, we vote on which procedure we're going to use that governs our protocol and our process. Robert's Rules historically has been what we've used. It's what we're using this morning. Unless anyone has an alternate that they'd like to entertain, we'll entertain a vote to approve Robert's Rules. Do we have a motion in that regard?
Judge Rambo moved that we use those.
Thank you, sir. We have a motion by Judge Rambo. Do we have a second?
Second.
We have a second by Mr. Mansfield. For roll call vote, Mr. Gibson,
Yes.
John Rambo,
Yes.
Marilyn Morgan, Kim Mansfield,
Yes.
and Earl Houston.
Yes.
Thank you very much. We approved the Robert's Rules then. We'll continue to use that for the rest of the year. Election of officers. According to the statute 29604F, it states this: at its first meeting each calendar year, the board shall elect a chair, vice chair, and secretary from its membership. No members shall be elected to serve more than 2 consecutive years in the same office. So this is the first meeting of the calendar year, so we're obligated under statute to have election of officers. Let me just remind you, our current officers right now are Mr. Collins. This is his second year, so he wouldn't be eligible to be the chair for, again. He could serve another office, but he wouldn't be able to be the chair on this round. The vice chair is Ken Gibson, and the secretary is Judge Rambo. So is there any discussion or nominations in that regard?
Would Mr. Gibson be willing to move up to chair since he's vice chair?
Sure, I'll do that.
Thank you, sir.
Then I nominate Mr. Gibson for chair.
And to make it easy, we could do it all in one package. Mr. Rambo, Judge Rambo, do you have any other nominations for the other?
Oh, I hadn't thought that far ahead.
That's okay. That's what this is all about. So if there's any discussion from the other members, we'd love to hear that. Do we have any ideas for vice chair then?
Would Mr. Collins, since he's term limited on chair, want to, I guess, drop down the vice chair? Or
He's not on the call, but I imagine that
okay.
if you were to nominate him, then we could always, of course, make an amendment at the next meeting. So you would be welcome to nominate him and then vote on that. So would you say Mr. Collins in for vice chair?
Well, I'll wait and see if anybody else has any nominations or anybody that wants to be vice chair.
I would like to nominate, this is Ken Gibson, I would like to nominate Marilyn Morgan
Or
for the vice chair.
okay.
I'll second that.
Okay. Well, then since Mr. Collins wasn't on the nomination, and I'm judging from Judge Rambo's second that that he would also approve. So we'll say Miss Morgan. Miss Morgan, would you be willing to serve as vice chair in that regard? All right. Thank you, ma'am. All right. So we have right now. Looks like the consensus is Mr. Gibson for chair, Miss Morgan for vice chair. So then we need a secretary. Now, Judge Rambo, I don't believe you've served that the second term. If you're willing to remain in that, unless someone has any other comments, then you would be welcome to do that.
I'll let anybody else have it if they want it. If not, I'll serve another term.
All right. Any comments or any volunteers? All right, Judge Rambo. Then, if this is where this is the consensus thus far. We have Mr. Gibson for chair, Ms. Morgan for vice chair, Judge Rambo to remain as secretary. Do we have a nomination for all three of those in that regard?
I'll nominate them in those positions.
Mr. Mansfield is nominated. Those three fill the positions as articulated. Do we have a second in that regard?
Earl Houston.
Mr. Houston is seconding that. Now for roll call vote. Mr. Gibson.
Aye.
Judge Rambo.
Aye.
Ms. Morgan.
Aye.
Mr. Mansfield.
Aye.
Mr. Houston. All right.
Aye.
Thank you, sir. Looks like we have a body then that election. Looks like we have our officers for another year. Thank you for that. If we can, we'll move to the. I do have one little sort of side note that I'd like to discuss about the random audits. If you recall, we went to a 10% audit. I just want to give you a quick update. We did 10% audit after our renewal cycle. And we only had one licensee that did not respond, so we opened up an administrative complaint. They didn't have their CEUs on file, and as the process requires. And now, of course, if they were to show proof of that, then that will be taken in consideration by council at the time in the legal report. But so that was the results of that. We had a pretty good. A lot of folks had their CEUs already on file, or they responded pretty quickly. So no problem. That went off pretty smoothly, as well as we could anticipate. Okay, looks like we're ready for the legal report then.
Good morning, Board. Dennis Gregory is not here today, but he did prepare the legal report, and I offered to read this into the record for him. There are only two cases on the legal report. What I'll do is read the complaint number. Judge Rambo and Mr. Gibson, I believe they already have a copy. Is that correct?
That's correct.
Okay. I'll read the complaint number in, give the Board a few minutes to review it, and then read the recommendation, and then take any questions from the Board. The first complaint number is 2019-000-961. It looks like council's recommendation is a letter of warning to remind the respondent of the guidelines contained in 0455-01-04-.01 being the standards of professional conduct, preservation of shorthand notes and any backups for a period of time no less than 5 years, or any period of time that complies with the rules or guidelines of the court.
I've got a number of questions about this complaint. I know there's a lot spoken about in here about audio files. I think, first of all, we need to establish what kind of a reporter this is. Is this an electronic reporter who would have audio files? If it's a steno reporter, the steno notes themselves stand for the record, no audio. And if it's a voice writer, they make a file as they go. So the question would be, there's a lot of concern about the audio. If it's a steno reporter, the audio is not the record. So not having the audio would not be a factor. The notes would be the factor. And the reporter says that this conversation was not taken down or heard by the reporter. And the objection overrode it. It's been my experience that an attorney has an objection and he pleads the fifth. That comes before any testimony. And it just seems to me that there shouldn't be a warning in this case. But it depends, of course, on what kind of reporter it is. Is it an electronic reporter? Do we know that?
I have the paralegal looking that up now. Carol's taking a look at the
To know what their licensure is in. Is it steno, machine shorthand, or is it voice writing, or is it electronic?
I have a quick question about this. In the facts, it states that the witness answered.
That was the allegation.
Does your analysis?
Could you bring your mic a little closer? There you go.
The analysis, yes, would. If it was a steno reporter and there was actually an answer made before, the steno notes would reflect that. And the transcript should be an exact rendering of the steno notes. But if it's an electronic reporter, the audio would be a factor.
Now, the steno notes, are you saying that while anything is being stated in the deposition, there should be a record?
Right.
Including if the statement was made prior to the objection,
Right.
then that statement would be there.
It would show up on the writing. It would show up. Even if it was garbled, you could just pull out that section and see if anything was written before the objection was uttered. So the audio, machine writers are not certified in audio. If a person uses audio, it's simply a backup, and it's a work product, and it's not the record. The record is the steno itself, and the transcript is derived therefrom. So that's why my question would be, if this is a person who's licensed as an electronic reporter, the audio would have to be maintained because that would be the backup.
We looked it up. The respondent in this case, I believe, is licensed as a machine shorthand.
That's correct. The designation is machine shorthand.
So the audio would be a moot point.
My only concern about this issue is that if the facts bear true and the reporter took it upon themselves to eliminate that statement, then that's an issue, because that would be a statement that would, if the lawyer objected thereafter, that would be a statement that would be taken up in court, and that statement may not ever come into evidence, and may not, because the fifth would ultimately take over or take precedent. But the fact that the reporter took it upon themselves to, if the allegation bears out to be true, to eliminate that statement, I don't like how that looks, because I think that the purpose of this board is to make sure that there are rules and regulations would be in clear violation of that, what our purpose is.
Well, of course, the respondent says that the objection was made before there was an answer, so we've got a he said, she said sort of situation. But
Mr. Mansfield, this is Ken Gibson. I apologize for interrupting. He did say there was an objection before the witness answers. That implies that there was an answer. And,
that's right.
And then his next statement is, the objection is in place of a response. And that is troubling.
We don't do that. We don't take out responses based on objections or ruling, even in court. If the court says sustained or overruled, we still have that answer in there.
But the respondent does say that the objection became before an answer, and apparently that's kind of vague, because it says interjected with an objection before the witness answers. Does that mean that the witness didn't answer at all, or the witness answered after the objection? In any case, the note should show it. So the issue is not with audio. I think it's another issue.
This is Judge Rambo, if I can say something. I was looking at the respondent's quotation, and that phrase can be read one of two ways. The court reporter omitting testimony, she says that is not the court reporter omitting testimony. It's an objection in place of a response. So I don't know whether the respondent is trying to say the answer, there was no answer given, the attorney objected, and that stood as the response. It could be just poor choice in language. To me, though, it's significant that this is a divorce case, and it's one spouse trying to catch another spouse, and neither attorney in the deposition have joined in the complaint to back up what one ex-spouse is claiming against the court reporter.
I will.
Here.
I'm sorry. Go ahead.
Sorry. I apologize. Now, I know the audio is moot, but I wish there had been, I would like to know, did the court reporter go to the audio and listen to see what was there? There's no report of that here. Was there anything there when they checked the sub-files? And if there was something there, then it would be the reporter's responsibility to say, okay, I went back and now I have found it on my backup files that, yes, there was an answer. And that kind of is, it's the same thing as NCRA says about inclusion into the transcript of comments picked up by videotape but not heard by the reporter. What you do there is everybody agrees that the court reporter missed something on the videotape, and the record is corrected with a note that says this was not originally heard by the court reporter, but was on the videotape, and that's what is reflected in that record. So I think there is some link there. If there was something on that audio, you can't just say, well, the audio doesn't exist, because it does.
And Mr. Gibson, to your point, the respondent did. It looks like I'm looking at the case file. The respondent did provide some audio. I'm going to ask my paralegal to go out and listen to that. So if we can just defer that case to give her an opportunity to listen to that, and then she can let us know, and then the board can make a decision from there, and we'll move on to the second case if that's okay.
That's fine. I just wanted to raise the point that a steno reporter is not an audio reporter. They're not electronic reporters. They're not digital. They're actually taking it down as it happens.
And audio is used for backup to produce what we produce. We've had this issue for years. They want our tapes. They want our, but we see things that may not be on audio. We hear things that may not be on audio. So that's the purpose of the live reporter. And this is just a backup.
Right, and so I think it sounds like the board is taking the audio portion of the alleged violation out of the question. We just want to make sure that witness didn't start answering before the attorney objected. We just want to see what actually happened there. And if that is the audio that was provided, we'll let the board know that, and you can make a decision from there.
I think that's important, that the reporter or the respondent can provide it to the board, but they shouldn't be required to hand out their audio to complainants. Or
I agree with that.
I agree with everybody's position. This is Earl. I agree with everyone's position, but it still concerns me that the allegation is there was a statement, then an objection, but only the objection is listed in the transcript. From that point, I think that it's our duty to look at the allegation and investigate the allegation based on what the allegation is on its face. At this point, one side is saying the response came after the objection. The other side is saying the response came before the objection. I think in either situation, everything should have been transcribed. So I don't think we should take that into consideration. I think we should investigate the issue, make a determination on whether there was an actual statement, or whether we can defer that there was an actual statement, or infer that there was an actual statement, and go from there. So I think this is a matter that needs further investigation.
Can we listen
Houston,
to this is Judge Rambo. Can we go ahead and let staff listen to it and then come back to this?
Yes, sir. That's what I have Carol, my paralegal, doing now. And we can go ahead and discuss the second complaint, and then she'll let us know what she hears. The second complaint on the legal report is complaint number 2019-013-511. And the recommendation in this case is to close.
Make a motion that we close.
Do we have a second in that regard?
I have a second with a comment that this is a cautionary tale.
Yes, sir.
That everyone should, when they're dealing with the public, make sure the public knows ahead of time what the cost is going to be, and you can't, and whether payment is expected up front or not. You can't just assume that the public knows the same thing and will treat you the same way as an attorney. But I second.
Okay. In regards to complaint number 2019-013-511, which is complaint number 2, we have a motion by Mr. Mansfeld to close that. We have a second by Mr. Gibson. Any further discussion?
Can I just make one
Please.
brief comment on this? This would all be taken out of the scenario if the attorney who hired the court reporter, that's who our, quote, contract is with. That's who should have ordered the transcript, not. And we're seeing a lot of that in domestic cases, that their clients are expected to pay us instead of the attorney, and that's not the way it should be. That's where all this trouble comes in, when they let the clients start dealing with it.
And it also states that the cost was made known and accepted, and then later tried to reduce the cost, apparently.
Okay.
And even used
That's right,
the criminal code, what they're paying for transcripts, which are for indigents, not for the public.
Those great comments. Any other comments? Thank you for those words of caution. In that regard, then, we'll do a roll call vote then to close that one, and then we'll come back to the first one and move on with other business then. For roll call vote for complaint number 2, Mr. Gibson?
Yes.
Judge Rambo?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfeld?
Yes.
Mr. Houston?
Yes.
All right, looks like number 2 is closed. And until we get our paralegal back with the audio recording, we'll move on then to legislative updates.
There were no specific legislative updates for the Board of Court Reporting. There are a couple of probably just department-wide things. I know there was a sunset on Commerce and Insurance that extended the entire department. There's a proposed change to the Fresh Start Act. I'm sorry, the Right to Earn a Living Act. It just kind of clarifies some definitions, but it's not in effect yet. I don't think that it will affect anything that the board itself does. It kind of goes to more administrative task. So that's the only update I have.
Okay. Looks like
Is that the Beacon Group outfit, the Right to Earn a Living Act? Is it Beacon Group that they want to do away with licensure? There's like a top 10 that they say are just, there shouldn't be licenses, and the court reporters are one of them.
I'm sure I would not be surprised if the Beacon Center did support that change, but I don't know for certain who proposed that to the legislature.
that's a pretty good guess, but yeah, I couldn't verify that either. I know that they are looking hard at some of our other programs, and I say I'm talking about Beacon Center, and they've listed that in some of their inquiries. Yeah, so perhaps that is the case. I don't know. All right, so that's it for legislative updates. If we can, then we'll move on to a new bit. Yes, sir.
Just a second.
Can we go back to the complaint issue?
Just to go back to complaint number 1, just for clarity of record, that complaint number is 2019-000-961. According to Carol, my paralegal, she indicated that the audio for the actual parties talking is not very clear. If you want to kind of explain what you could hear.
Well, I can hear the court reporter setting up, and I can hear her speaking to, I guess, parties, saying, well, I'm just going to set up here, and, that's okay, I'll just put this here. And then there's a lot of murmuring in the background that cannot be heard over
Her actually taking
the actual clicking of the keys. So I can't hear whether or not there's an objection. I can't even get a conversation or a question and answer.
to decipher the voices.
And it could just be because I'm not plugged in and I don't have my headphones. Because I jacked the noise all the way up to 100 and I didn't hear.
So unfortunately, that's all that we have to go on at this time. The respondent would be the only person with that audio recording, and that's what we were provided with.
That's why I think that the steno notes would be the key to a machine writer.
And they could be simultaneous. They could be objection and answer going on at the same time. We cannot get two,
Yeah.
So that could be an issue.
Well, in light of that, what is the warning then to remind the reporter? I mean, they did provide the backup. They had the backup and they provided it. So what are we warning the court reporter to do?
And let me just say that is just Dennis's recommendation. Of course, the board does not have to accept that. If they see other discipline is necessary, that can be done. If you want to change what the letter of warning should be to advise the respondent of, you have the authority to do that. If there are other ways that you see fit for investigation, you can authorize that as well.
Well, this is Judge Rambo. I think if we do a letter of warning, that we maybe not necessarily say that it happened, but it should, the court reporter should be cautioned that they are not to remove or omit any testimony and overlay the attorney's objection in response.
But should we be accepting that the court reporter did anything wrong? The court reporter asserts that nothing was done inappropriately. Why would we assume that just because someone made a complaint that the court reporter has violated anything?
The respondent's answer was unclear, where she states objection in place of a response.
And just to further clarify for the board's information, it doesn't necessarily have to be a letter of warning. It can be a letter of instruction. It can be a letter of caution.
Instruction would be better.
Right. So whatever the board decides is what we can do, from letter of instruction all the way through,
It shouldn't be based on audio at any rate. It should be based on the steno notes. And no one has seen the steno notes. So I don't know that we can pursue any further at all.
A letter of instruction would not be considered discipline. It's just a letter from the board saying these were our concerns.
That would give guidance.
I'm not a whole lot concerned if she, the only way you can really solve that is to look at her synced transcript and listen to the audio while you're looking at the transcript. I have attorneys who whisper objection, and the audio's not going to have it. So did he object or not? That's the steno reporter's job.
I guess the question is now, based on your responses.
I think the investigation is complete, and I think there's no action that should be taken.
I think requiring a steno reporter to hand over audio and rely on that solely is dangerous for all of us.
Other comments?
I don't see that as being the point here, but I agree with you 100%, but I don't see that as being what we're doing here. But
what do you see as the point, Ken?
Okay. It wasn't whether she kept the audio or not, or used the audio or not. It's just the troubling question of, can you replace an answer with an objection? That is the point. It doesn't really have anything to do with turning over audio.
And I think that's a valid concern. I think what we have to be careful of, we have to go with the case in front of us. And I think the issue with this particular complaint is we aren't for certain, based on the information we have, that the transcript is showing that they replaced a witness's answer. So if we we don't want to issue discipline for something that we don't necessarily have probable cause to believe actually happened.
Right. Well, this is Judge Rambo. I don't think anybody is advocating discipline for replacing an answer. The record does not substantiate that has happened, but the allegation has been made, and the court reporter's response may have just been not well drafted. I think it's sufficient for us to say there was no finding that occurred, but you need to know as a learning from this experience, if you don't already know it, do not substitute an objection for a response given by the person testifying.
That's assuming that it actually happened, though, and I have a problem with that.
This is Earl.
Not assuming that it actually happened. The preference was we did not assume that it happened.
This is Earl. I agree with Judge Rambo's statement regarding this issue, and my reason why is we've taken upon ourselves to investigate the matter. We did that by reviewing the audio. It was determined that the audio was unclear. If you take into consideration the other facts that are in play here that Judge Rambo mentioned early on, that the lawyers that were involved with this particular deposition, they have not made any allegations as it relates to these statements. This is a domestic matter. We know that they can be contentious. So the only thing we have to go on are the facts that were provided to us by the complaint and in the response. And at this point, we cannot make a determination as to whether there was a violation. But it's still a little unclear as to whether the respondent actually understands that they cannot take that action of replacing a response with an objection. So I like the idea of providing a statement regarding our findings and just a general instruction that this is something that you cannot do.
In that statement, you would be telling them that we're not that's not substantiated. You would be letting them know that we're not claiming you did that.
Yeah.
So
it would be a statement that essentially says the board found no violation. Possibly because I don't know the exact language right off the top of my head. I would say the board found no violation. However, we would like to instruct you that as far as the testimony, you cannot replace that with an objection. All statements must be included in transcripts in some way. That is what the instruction would say.
Hey, I respectfully request that from this time forward, the reporter's method be taken into consideration when we're looking at these things, because the court reporter could have easily provided the transcript along with the steno notes, and they track simultaneously. And you could see if anything was left out or not, or somebody who's trained could. And audio is irrelevant.
I agree with what was just stated, and maybe in the summaries that we get, when it as to that court reporter, we need to know the classification, because it does assist in helping us decide whether it's a pertinent issue or not.
Absolutely, and I actually took that note as you guys were discussing when we looked up the respondent's designation. I took a note to add that to the case caption.
Thank you.
Mm-hmm.
So as it stands now, from what I'm hearing, and someone please correct me if I'm wrong, it looks like we're moving with a letter of instruction based on the structure so articulated, where we render the findings that the claim was unsubstantiated, and whereby we just instruct them on what their responsibilities would be, whether they understand that or not, just as a due caution. Is if that's the understanding, or if that's what the board would require, we just need a motion in that regard.
More, I would think, than just for your information. instead of anything
No,
directed to anyone in particular.
Yes, that's a good idea.
Very well. All right, so we is that in the form of a motion then, Mr. Mansfield, or did someone else want to make that motion?
Make a motion to give them a for your information letter.
We have a second in that regard?
I'll second it and add if the movement would agree that we dismiss the disciplinary complaint formally.
Okay. In that regard, then, would that meet your approval, Mr. Mansfield?
Yes, I'll still go with a motion in that regard.
Okay, that sounds great. Then with Judge Rambo's second, we'll do a roll call vote in that regard. That would be for complaint number 1, and that is 20190000961. We have Mr. Gibson,
Yes.
Judge Rambo,
Yes.
Ms. Morgan,
Yes.
Mr. Mansfield,
Yes.
Mr. Houston.
Yes.
Thank you, Board. I think that takes care of the legal report then.
Yes. I do not. Thank you, Board.
Okay, if we will, then we'll move on to new business then. And then on the agenda, we have digital electronic licensing discussion. That would be, we're going to go 2 items. There's item number 1 on your iPads, which would be number 5, and then number 6, item number 2. And then, Judge Rambo, I sent those to you yesterday. Mr. Gibson, I apologize you won't have that in front of you. I'll send that to you. If you have any questions along the way, please pipe in, and then we'll try to clarify the best we can. Okay, sir?
Thank you.
May I introduce Ms. Wilson? She was going to start that discussion off. She was one that provided the supports.
I'll just hold it. Okay. First of all, I'm Sheila Wilson, court reporter from Chattanooga, Tennessee. I want to thank all of you for your board service. We know it's always, we're happy to have you. You don't get thanked a lot, so we do appreciate you. And I apologize, I left my dress clothes on my kitchen counter when I left Chattanooga last night. This may or may not be appropriate, but I thank all of you for your participation on this last complaint. Just off the top of my head, on the replace answer with an objection warning, that's kind of concerning, and I think it would be for most court reporters. If I were to get a letter like that, I'm going to tell you how I would interpret it. If I were in a deposition or a trial and there was an answer and an objection at the same time, and I wrote, we'll just say, the objection, because in my world, the cat that meows the loudest gets the milk. You do the best you can. But if you have a simultaneous answer with an objection, if I got a letter like I believe the disciplinary council is anticipating, I would interpret that. I'm not saying anybody else would. I would interpret that as an instruction that I am to write that person's answer over writing the objection. Is that making sense? And I'm not sure that that's what the board is. That's just a comment. Oftentimes, we're always in situations where answers and objections are given at the same time. And what is a reporter to do? So a letter of instruction or a warning or an FYI letter would send that message to me as an individual reporter. And that's just a comment for what it's worth. And I think the reporters here would, certainly understand those. And kind of along that, I'm sorry. I want to talk about my item number 1, and it has to do with backups. And I would ask clarification from the board under your Standards of Professional Conduct 455010401. When it talks about the plan and preservation of steno notes and any backups, both paper and electronic, does that standard apply to matters not yet transcribed? Because it's not clear, and it will be important legislatively, we'll just say. And I would ask for the board to clarify that, and if the intent is to be I've always assumed it was for matters not yet transcribed, but if it is intended to mean all matters, I would ask that the board consider informing the licensees of Tennessee of that intent. Is that making sense?
It does.
Thank you.
And I always understood that A backup is for something that has not been transcribed, because the court reporter's transcripts is the record. It's the official record. And in that case, there's no need. Of course, it's a good idea to keep it anyway. But I think this is specifically talking about something that hasn't been transcribed.
May I request the board make that clarification to the licensees via an email blast, however you can do it. I think that's important for them to know that.
Of course, at the same time, though, you shouldn't throw away your archives either.
Oh, I
For at least
agree.
5 years.
I agree.
So it's kind of all encompassing, but
This is Ken Gibson. It just seems natural that you would want to be able to defend yourself by saving your audio. But that's just my opinion. But I know people who just say, no, you're not. Nobody's going to ever get to hear them but me, and that's it, final. But.
And I agree with Mr. Gibson. I agree with you. This is Sheila Wilson. Exactly what you're saying. I understand your point. But as an example, say if the matter were a year later, we'll make it up that a reporter is in court and may transcribe a court ruling. May or may not have been recorded, but if they did record it, transcribe the ruling, and all parties signed off on it, and say a year later or so, one of the litigants contested that, the reporter who may or may not have created audio may or may not still have that. And I think the clarification of this rule may be helpful. I know there's a lot of may or may not haves in there, but there's reasons that I'm asking that. There is and I'll just come right out and tell you, that may or may not situation may or may not be the basis behind a potential piece of legislation that is not yet moving through the House and Senate at this point, and we're just trying to get a little bit more information on why the bill, that particular piece of legislation, was filed, and the bill sponsor is not clear from his or her constituent on exactly, but it is a domestic matter, on whether or not there was an audio, and it seemed to be perhaps a year later. And there's, again, a lot of unknowns from that constituent, and that bill sponsor has agreed to go back and speak with their constituent and ask more questions. We don't even know actually if there was a reporter there. But I was hoping to go to the rule here and be able to discuss this with the legislator that, hey, the rule says thus and so. But then when I'm looking at that, does that mean I always interpreted it to be matters that were already transcribed?
Ms. Wilson.
Yes, sir.
Judge Rambo.
Yes, sir.
What legislation are you referring to?
Your Honor, it's a piece of legislation that has been filed requiring audio to be implemented in all civil courts, circuit and chancery and general sessions in the state of Tennessee. That piece of legislation, sir, has not moved out of actually has not even come before any subcommittee at this point. It's being held in abeyance by the Senate sponsor at this juncture.
Do you have a bill, a Senate bill number or House number?
I do, but I'm so sorry that's not right on my Yes, I can tell you the senator's name, if that's helpful. I can provide you that bill's number later, but it's Senator Bailey. And I don't remember who the House sponsor is. Tennessee Court Reporters Association, in full disclosure, Tennessee Court Reporters Association Legislative Committee has met with Senator Bailey, and we had a long discussion. He was, quite open. We explained the civil process as compared to criminal process. We explained our jobs as court reporters, and I believe that he would agree. We gave him a lot of information, he was not able to provide some answers to our questions. But he did agree, ma'am, to take some of the questions and suggestions that we had back to his constituent and to get back with us, meaning TCRA. So that's on our TCRA's radar, so to speak, but we're hoping we can address that short of legislation. And our goal and certain fervent hope is that that piece of legislation will be withdrawn. So,
if I could interject something, this is
yes, sir.
Rambo again.
Yes, sir.
In one of my courtrooms, we do have video, audio recording going on all the time, and from my perspective, the reason why I implemented that, if there was if there's a complaint of judicial misconduct that I berated somebody in front of me or did something wrong, I could have a video clip that would capture my tone and everything that I could submit to the Board of Judicial Conduct. Or if there was a fight or a physical incident, we would have a record. But most significantly, I have that if we get attorneys in there and there's no court reporter and I give a ruling, and then the attorneys are in dispute on what should go in the order, I can pull that up for my purposes to refresh my memory on what I ruled from the bench. And none of that was designed to supplant a court reporter. But what does concern me is I had a case where the attorneys knew that I was making a recording, and I ruled, and one of the attorneys decided to do an interlocutory appeal and ask for that recording to take it down to the Court of Appeals. And I think what we need to concentrate on is to make sure if the judges or the court clerks are recording, that cannot be a substitute for a court reporter for a transcript.
Judge, this is Ken Mansfield. It's been my experience that when I'm in a courtroom that normally records, they'll turn their equipment off if I'm there. But that probably may not be always the case, but they usually turn it off if I'm there. They say, well, we have a court reporter. We're not going to use our recording equipment today.
And Judge, this is Sheila Wilson again. In speaking with the legislator, we, TCRA's Legislative Committee, is not entirely sure if the ruling that was, or the order that was prepared was reduced to writing from a court reporter's notes, or if it was just a ruling from the bench. Anyway, that's kind of where we are. And I felt that it was important to have clarification because the senators seem to be concerned that there may or may not have been an audio from their available to their constituent. We don't know even that the attending reporter audio taped or not. Not everybody does. So we're kind of in a holding pattern again there. But I did, again, not to beat a dead horse, felt that clarification on this might be helpful, and just in general, for general reporters as well. That's the reason for my question.
Just from looking at this, it looks like...
Because I'm a little concerned that attorneys are going to want to be cheap and somehow push on down the line that let's just use the recording that the court made, which is no substitution for a court reporter.
I fully agree, Your Honor. And that's why the Tennessee Court Reporters Association is in great hopes that we can make this bill go away before it starts passing down the pike.
And I would like to say, Your Honor, you just gave a great argument for why court reporters don't want to give their tapes up, because you wouldn't need court reporters. It's just
exactly
right
recording devices.
Because what happens is under the rules, if there's on an appeal, if there is no transcript, i.e. from a court reporter, the attorneys can write one up and submit it for the judge to approve. they could easily just take the recording from the courtroom, have their secretary transcribe the best they can, and say, this is the best record that we have, and there was no court reporter. A lot of times, if that was the trend, that's a risk that to the profession of court reporting. So the court reporters need to have that on their radar.
How would this help, Sheila?
I wonder, Ms. Morgan, if it were just made, and I'm talking off the top, I mean, I'm kind of thinking out loud here. I was kind of hoping we kind of brainstorm and come up with something. I'm wondering if you could just make it clear that it's the option to always retain your audio if you have it, but that the preservation of the shorthand notes, actually, that should probably just be notes. I'm not sure how to clarify that, since we now have voice writers and electronic. That just sort of, I guess how could you say that? I guess backups should be, I don't have an answer for you. I really don't have an answer for you. Maybe for matters already transcribed?
Well, of
That
course,
it's an
then you'd
option,
still
but not
wanna
a
keep them for
requirement?
5 years, even if they're transcribed, in case somebody needs something within the 5-year period.
Right, but as to the audio,
Right.
I don't know, but I'm hoping we can do something there.
There be something to the extent that backups are only used for clarification of a transcript.
I think it gets back
Production,
to a steno reporter is not an audio reporter.
Right.
So their backup is not necessarily an audio.
Right.
It might be used or it might not. So I think in the case of a steno reporter, it would be shorthand notes or any backups for 5 years. Covers it. But this obviously doesn't cover voice writers or electronic reporters.
But wait, when you say backups, the backup is kind of broad. But types of reporters use different methods of backup, right? Some reporters use electronic means, audio, voice writers, so forth.
This is only talking about shorthand reporters.
You're saying shorthand reporters use notes and what else?
not necessarily notes and notes and notes. We might have a backup here, a backup there, backup on our writer, a backup in our iPad or laptop.
Right.
That's what we consider
I have 3
backups.
backups
Yeah.
of notes. I also have the files completed. I have that one in 3 or 4 places also. I'm backed up.
Well, I guess my question surrounds if you use the term backup in our rule, would that cover the methods of backups for the various types of reporters?
It probably would, but the problem is it says shorthand notes. And that only really applies to machine writers or hand writers, pen writers. So this was probably more than likely lifted from a pattern of another state's licensure law, and perhaps they only had steno reporters. They didn't have voice writers. They didn't have electronic reporters, and so that's the quandary that we have. It really only addresses one thing, but it can be broadly including all methods if you take it when it says both paper and electronic. That could include any kind of way that they've taken the record.
Judge Rambo, what is your analysis of that issue?
My thought on the whole thing is we're not specifically requiring them to have backups, period. And to me, all of that is to create your record. And once the record's been approved or given to the attorneys, I think you should only have to keep it for maybe 6 months after it has been completed and do away with the 5-year requirement.
No, Judge Rambo, something I forgot to think about, which I always do. It's in a deposition, the witness or the deponent has a right to read and sign.
Right.
Most people don't ask to do that, but if you fail to do that, you waive your right to
I agree with
to
that.
object to any
Yeah.
changes, right?
Yes.
So does that cover the issue of the requirement of a backup?
To me, that's why I was kind of thinking 6 months to get you beyond that period, because we want to get away from the concept that these backups are somehow superior to what the court reporter has produced, and that we're going to start second guessing records, and we're going to maintain all of these avenues to second guess a record for 5 years. That just seems to me a burden on the court reporter that's not
Well put.
really necessary.
I agree. You have
I
a
agree.
suggested fix?
I don't have a problem with the 5 years personally, but I think that I'll go along with Judge Rambo totally in the fact that if the record has been completed, it has been put to paper or electronic form in its completed fashion, I think you should still keep that for 5 years in case someone else needs it in the future. But as far as all other backup or any incidental backups, I don't think would be required to be kept if the record has been made and has been approved.
Any
I think
backups,
you stated it better than me.
any backups
Well-
that aided in the transcription of that deposition or hearing or whatever, those are gone. After we've certified the transcript, there's no reason to keep anything that might have aided us in preparing it.
Correct. The only thing that we should keep, though, is a copy of that. Well, actually, the original resides on our computers. The original transcript.
Right.
I want to make sure we.
I think that's what you're talking about, the real
Yeah.
backup.
That should be kept for 5 years.
Yes,
Right, but-
the real product should be kept 5 years.
Okay, this is Sheila Wilson again. I'm thinking out loud. We know that's dangerous. If I go back hypothetically to this senator and say the Tennessee Board of Court Reporting has clarified whatever you say in the way of audio, because that, I think, is what they're talking about. Again, some of it's a little unclear. Because at first we were told there were no notes or audio. Well, I don't think that's right. I think it was just the audio. How can I use, well, I'll figure it out. Y'all
I will
decide.
just say, until the board has voted, I would caution you against saying that
Okay.
the board has decided. I think they're giving you their expert opinion.
I'm sorry, and I didn't mean to imply that. Yes. Sorry.
I guess you'd say that the reporter's product, if they're a steno reporter, are their shorthand notes. If they're a voice writer, it's their voice file. And if they're an electronic reporter, it's an audio file. And I think that's where a lot of the confusion's coming in, is people are not differentiating how actually the record is made. Some people probably have the idea that a court reporter makes an audio and then just types from it. And we're just sitting there on that machine just to look fancy. But it's not the case.
This is Marilyn. But it would be different for jobs that have been transcribed versus jobs that have not been. For audio, anything, they should not be the audio reporter should not be required to keep audio if they've prepared their transcript, just their transcript. I'd like to get away from the the reference to, hey, audio, you've got audio. You see what I'm saying?
I do.
It would apply in the same regard, I think.
Well, it's interesting when you look at this because it's the preservation of notes and any backups. If you really think about that logically, that's a raw form. That would not be a transcript.
This is Earl. I think that we're having a conversation about this issue, but it doesn't how to respond, and we have varying. I don't know we can do.
This would require, from what I'm hearing, it looks like we may be moving towards a rule change. And so what I would recommend is if folks could send me their recommendations for to the wording on that on a draft. And right now, I will also warn you that we're in a moratorium on all rules right now, so we wouldn't be able to even consider it until after May. But our next meeting obviously is in September, so that wouldn't be a problem. But right now, we wouldn't be able to move on any rules until we're past the governor's moratorium on all rules. But if you could send me your comments on this particular one, and then we could have that discussion at our next meeting, we could welcome that in. Any comments in that regard?
Well, I would like to make one comment. It's kind of what I've already said, and I don't want to be too redundant. But when just the clear reading of this is not talking about transcripts, it's not talking about the official record. It's only talking about preservation of notes and any backups. So it's actually not referring technically to transcripts. It's talking about a reporter, whatever their methods, raw input before the transcript is developed. And I have absolutely no problem with that being maintained for 5 years, pending it's being requested. But I don't think that this in itself is referring to transcripts.
That's correct. But if there's anyone on the board that may have comments to that duration, from what I'm hearing, it seems like some folks may have a problem with the duration, or not, maybe not.
Not at all.
Not
the way it's written. I have no problem with it at all.
Okay. Any other comments?
Well, I would just add this: the style where it says item 1, clarification on weather. Maybe we just need to put within subpart G, or if I could see the rest of it, it would make more sense. But if we had a interesting statement as to matters not yet transcribed, the court reporter shall establish a plan. You know, if you put that at the beginning of G, it may make everybody feel better.
Yeah, that would be a simple clarification that would do world of good, I think. The matter's not transcribed.
What I'll do then is just request that formally, and then if each of the members could just reply something in that regard, I'll send you that. I guess that snippet of that part of the rules, and then you can just send me back your comments in that regard that would satisfy what you're aiming for, and then at the next meeting we can present that in some form of a draft.
If we just put at the end of the statement, shall establish a plan for the security and preservation of notes, perhaps we should say instead of shorthand notes, and any backups, both paper and electronic, not transcribed.
I think from a procedural standpoint,
Right.
We have to take the course that is being recommended.
It does sound like we've got some ideas in that regard, so we're moving in the right direction. And then once I send that to you, if you just reply in that regard, and then we'll come with those variations, and we'll have a working draft in, and we'll be ready. That sounds good. All right, then we'll move along to number 2 then. Ms. Wilson?
Me again.
Yes, ma'am.
Again, thank you for that lengthy discussion. I thought it would be something short, and I'm sorry for having taken up so much of your time on that. But I guess what I'm asking the board is for input. Board member Mansfield began this discussion with the Tennessee Board of Court Reporting when it was under Office of Administrative Courts. My vague recollection is the discussion was kind of tabled at that point, and the board was going to address it at a later time, and life went on. We all understand that. So here we are today. I'm going to kind of give you, in a nutshell, I thank you for allowing me to give you some documents. I did send to Glenn in his office, I'm sure, Mr. How you pronounce your last name? Kopchak. Sorry, I don't want to call you Glenn. Mr. Kopchak gave to you what I put together as we all understand that the voice writers, their national organization is the National Verbatim Reporters Association. And Judge, I'm kind of giving this a snapshot for you since you may or may not be aware of some of these acronyms. The NCRA is the National Court Reporters Association, and they offer certification for pen and steno. The electronic persons, They too have a national organization. That is, those initials are AAERT. That stands for American Association of Electronic Reporters and Transcribers. Now, I was not part of the legislation at the time that the Court Reporter Act was enacted. It was kind of on the periphery. I am not clear, to be honest, at the time that the licensure law came into effect, whether AAERT, and that's the organization I'm speaking of today primarily, I'm not clear if they had one basic certification or they had more than one. Now, I do know at this point they have two, and this is their bottom, maybe the only certifications. One, a person earns what they call a certified, I'll see if you look under their AAERT certification program, they take their candidates, as best I can determine, take an online multiple choice questionnaire. And if they successfully pass that at a rate of 80% or greater, they are awarded a certificate that says Electronic Court Reporter certification. That does not require them to produce any transcript at all. The other two national organizations, those being for the voice writers and the steno and pen, have to pass two separate tests. Written knowledge test and what we call skills test. In my vernacular, the CER exam from the electronics is only a multiple choice. There is no skills test. There is no production test. By my reading, and I could be incorrect, I hope I am. I really hope I am. But I believe that a person with only having passed and in possession of the Electronic Court Reporter certification can then, by law, come to TBCR and under their rule 4550103, where it says submit an application to be licensed, blah, blah, blah. Application shall include proof of passage of, and you skip down and you see AAERT Certified Electronic Court Reporter Examination. By my understanding of the current rules, and perhaps the law as well, that is really all that is required to obtain a license from the Tennessee Board of Court Reporting as pertains to electronic only. Now, electronic, the AAERT has a second certification that they call, and I've provided to you, let me find it here, their CET. That requires an online, and frankly, this is more in line with what the other two national organizations would give, as best I can determine. It requires an online multiple choice test, just like voice and steno for online written knowledge, and it also requires for them to type up and produce 10 to 20 pages of transcript. Even though it's not apples to apples, at least they're producing a transcript, and that would be what I would kind of equate to a skills test for the voice writers and the steno writers. But we have a little disconnect with the electronic, in my opinion, being able to obtain a license with only having passed and following along that, and then I'll hush up and give the board a chance to discuss. When I was looking at this morning, I'm just wondering, say a person, an electronic person, has a license from TBCR, and they got it, we'll say, through the CER. Okay, so they are a CER licensed reporter. When you come down to TCA section 20-9-608, 609B, section B, where it says no licensed court reporter may authorize the use of a court reporter's license on any transcript not produced through the court reporter's personal effort or supervision or both. So my question might be, for those CE, and I'm only talking about the electronic stuff, because that's where I have a little hiccup. For those who have never transcribed a transcript, if they permit someone to put their license number on it, are they in violation of Section B? Do you follow me? And I don't know the answer to that. And I don't know how to correct this. So I'm asking, and certainly opening it up for dialogue since Mr. Mansfield addressed that. I have one other thing, and then I'm going to sit down. I believe on your questionnaire, on your application for licensure, there is a requirement to determine or list out your method. I think I'm right, and I apologize if I'm incorrect. I think that there is an option to list digital, and then there's also an option to list electronic. Is that your recollection, anybody? Is it an either or are they listed separately? Do you know?
It can be listed separately or together.
Okay. Well, my suggestion only would be to eliminate the word digital, because nowhere in the statute does it mention the word digital. It only talks about electronic under the actual Tennessee Court Reporter Act. And as well, TBCR's rule under their application for licensure. And it seems to me that the word digital, just take it out. There's no reason for it that I can see. And when I was I posed a question to the TDCI, too many acronyms that start with T, on the number of certified electronic reporters and the number of certified electronic transcribers who were granted a license within, say, 2 years. I think, in all fairness, the word digital kind of created a hiccup in their population of the information. So it seems like that eliminating that and just calling it electronic, because that's what the law speaks to. So I'm going to sit down, and I appreciate you all hearing me out. Don't know if you can do anything. Just thought I would open it up, especially since Mr. Mansfield brought it up some time ago. And thank you all for your time. Appreciate you.
Thank you, Sheila. This is Ken Mansfield. I remember, as Sheila went over it more and more, I remember the discussion that we had, and it was one that I did raise, in fact. And I was concerned at the time because the law says CER, which is electronic or certified electronic reporter or recorder. I'm not sure which is their designation. Reporter. And at the time that I brought it up, they had a designation called CERT, which was certified electronic reporter and transcriber. And I was bringing up to the attention that would be more in line with what the steno writers and the voice writers have to do, because in order to get a license, we have to demonstrate the ability to take the record down and then produce the record in the transcript form. And ours has to be 95%. Theirs is considerably lower than that. But that's what we have to do. And the discussion at the time went back under the AOC was that would probably require additional legislation, because the underwritten law says CER, not CERT. And apparently, Sheila has brought up the point now to where they have yet another designation. You can be a CER or a CET. I don't know if they've done away with the CERT or not. But it seems inherently unfair that two groups in Tennessee have to demonstrate very high skill level and produce a work, and when another group is allowed to go online and take a multi-choice test, and then they're designated the same as someone who's had to take down and produce a transcript. It just seems inherently flawed.
I will say that the rule currently in effect is a direct reflection of the statute. So those designations were in the statute, and that's what carried over to the rule. The board does have the authority to kind of craft rules and determine what tests are applicable as far as their application process. Again, that will require a rule change, and as Glenn mentioned, we are in that regulatory freeze mandated by the governor, and so that's another change that we couldn't address. We couldn't address that until that freeze is lifted.
Did we
Judge
change it
Rambo,
to?
I agree. There's a deficiency if you can be certified as a court reporter in this state and you don't have to pass a skills test.
And that is something that the board does have the authority to require as part of their application process, something that they have to, that applicants would have to submit in order to be licensed. But again, that will require us to draft rules to that effect, because as of now, we would just go by the statute, which doesn't necessarily have that designation in it.
I think it's in the public's interest that this be changed, because we have people actually uncertified who think they're certified at this point.
I don't understand. And I guess I need this. I have two court reporters, one certified in transcription and one's not, right? One's just electronic.
According to law, you don't have to be certified in transcription if you're electronic.
They run them.
Can they transcribe?
Not according to their licensure.
Okay. Well, then that just means they can't provide a transcription, right?
But the law says they can get a license if they get the CER, which doesn't have anything to do with transcription. That's the problem.
I think about it like in varying degrees of lawyers. Like, I'm a lawyer, but I'm not admitted to the patent bar. I can't write a patent. So in the court reporting world, this particular reporter is a reporter, but they can't create a transcript.
Well, if you can't create a transcript, you're not a court reporter. In the court reporting world, that's an inherent part of being a court reporter, is being able to produce the transcript.
But they're in violation of our rule if they farm it out, right?
They can be under their supervision, but they can't put their number on it. See, their license doesn't allow transcription. So they're really not a court reporter unless they can transcribe, would be the position of everyone else. But
Judge Rambo, were you trying to make a comment?
Well, most of the court reporters that I have are recording in Northeast Tennessee electronically, and just hearing them talk, the person who is in the courtroom is the one who's recording it, and they are the ones who put their license number on the transcript. But then they have other people who I don't know are out there transcribing it for them.
And this is Marilyn. Under the section 29610, the reciprocal agreements, it gives us authority if the board finds that the state agency or other entity has substantially the same or more stringent requirements as the board. I mean, it looks like we have authority there to say, you know, they need to pass both under the reciprocity agreements.
This is Earl again. From a cost standpoint, the electronic reporter, do they make as much money as
they don't.
How much do they have to pay somebody to transcribe? Or even court reporters who have SCOPUS. They don't make as much money as somebody who stays at home and does it themselves, but they're able to go take more jobs. There's so many variables you can't say which one would make the most.
They can charge the same per page as everybody else.
My only concern here is that let's say that there are varying degrees of court reporters who have this designation, they're allowed to transcribe. Have this designation, they're not allowed to transcribe.
Mr. Houston, could you read so they can hear you on the phone? Sorry.
I'm sorry. There are provisions in our rules that allow them to have someone else transcribe their work. So really, there is no discrepancy in our rules. It would just be a rule change to make it from the standpoint of what the requirements are.
I think the big discrepancy is all other methods have to be able to demonstrate takedown and production. This particular group does not have to produce. So it's not really the same.
And I would like to, the word transcribe can be ambiguous. What are we talking about? Transcribe from what to what?
Transcribe from the raw form to a transcript.
Well, yeah. I consider a scopist as a transcriber as well. That might be outside of, so it's just a kind of an ambiguous term. But that could be defined.
I think this is something this is Earl again. I think this is something that the board should take under advisement. I don't think this is something we can handle today because of the nature of how the rules are written and
the underwriting law that governs the rules says CER, and that's the problem.
Because these others were not established at the time?
I don't know.
There's probably some that were grandfathered in. But I tell you what, we're gonna be presenting a draft for the rules regarding item 1. We can do a working draft for item number 2 as well at the next meeting, and then formalize that discussion and come to some sort of consensus that we're all comfortable with, and then take action at that time. And then by then we'll be past the moratorium as well, so the timing of that will be just right. Does that comport with what everyone would like to do? Or is there any additional comments to move this along in that regard?
Can we again send in suggestions of how the
Yes, sir.
language should be?
Yes, sir.
Okay.
We welcome that.
Okay.
That would be an integral part of that draft. And then obviously I'll when I reach out to you for the first piece to get that conversation started, I'll blind copy everyone, and then so if you reply, it'll be just to me, so we're not in violation of sunshine laws. And then we'll get to a place that we feel really comfortable with the first draft, and then we'll kind of tweak that at the next meeting until hopefully we can get to a place where we can vote on that. Does that sound pretty good to everybody?
Sounds good to me.
Okay, great. Unless there's any comments okay. I think that does it. Unless anyone has any more comments for the new business portion of our agenda, does anyone have any comments in that regard? Okay. Well, it looks like we've done some heavy lifting today. We've got a lot of work ahead of us, so I think we're at a good place. I'll go ahead and have to entertain a motion to adjourn then.
Motion, we adjourn.
We have a motion from Mr. Mansfield to adjourn. Do we have a second?
Second.
We have a motion from Ms. Morgan to adjourn for roll call vote. Mr. Gibson?
Yes.
Judge Rambo?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Houston?
Yes.
Thank you all very much. We are adjourned. And gentlemen on the phone, thank you so much. We look forward to talking to you soon.
Thank you.
Thank you. Have a good day.
Thank you so much. I appreciate it.
Have horses still?
No, my family, I was 11th, 12th grade.
Oh, yeah. Well, you got to do something to keep everything lively, don't you? Hi.
I'm Lisa Moss.
Good to meet you, Lisa.
Say, excuse me, too much. Because
The last horse died. It was a family. The last horse.
What's going to happen when pizzazz
Had a
goes?
funeral and everything.
Yes,
But he lived to probably be about
In the Senate and installed in the House back in February. So.
Right.
Do you know?
And the House said.
That's what they're probably trying to push.
Mine's 14, and he's really just in his prime.
He lost all his teeth.
That the
we put him. They had him in the stable by himself for I don't know